Good afternoon, and welcome to today's PDAC webinar, Antitrust for Americas, UK, Europe, Important Competition Law Considerations in Recent Mining Mergers Around the World, which is the 11th of our 16 sessions in the Fasken series. My name is Frank Mariage. I am a partner in Fasken Montreal's office and a member of the PDAC Program Committee. This is Fasken's 11th annual PDAC seminar series. This year, we are doing it virtually, like PDAC itself, which started yesterday. We have people joining us today from all over North and South America, from the UK, Europe, and South Africa. We are also broadcasting this on YouTube Live. Once again, welcome everyone. Before we begin, a few housekeeping notes. At the end of the webinar, please click the survey link underneath the video to fill in our survey. Your input is greatly appreciated. During the webinar, if you have a question, please type your question into the chat box beside the video. Today's panel will do their best to answer all the questions they can. If you require technical support, please click the tech support link, which is located underneath the question chat box. The speaker bios and materials from today's webinar can be accessed from the materials button under the video player. And now I turn things over to my colleague and partner, Tony Baldanza, who is a competition law practitioner in our Toronto office. Tony, over to you.
Thank you, Frank. And many thanks to our audience for joining us today. We're very fortunate indeed to have recruited 4 outstanding competition lawyers and the immediate past head of the Canadian Competition Authority to discuss competition law considerations for mining mergers around the world. So let me begin by introducing our panel to you. Katrina Groshinski is a partner with MinterEllison based in Sydney, Australia. Katrina regularly deals with the Australian Competition and Consumer Commission and advises clients on transactions requiring foreign investment approval. She has a wealth of experience in highly regulated industries, including mining, and she undoubtedly wins today's prize for the most sleep-deprived person on the panel, given that it's 4 a.m. in Sydney. Turning to Amadeu Ribeiro, he's a partner based in the New York office of Mattos, Filho, a leading Brazilian law firm. Amadeu has been ranked one of the top 40 antitrust lawyers in the world and is highly experienced in assisting clients in navigating Brazilian competition and regulatory law. My colleague, John Pecman at Fasken, is a senior business advisor in our competition marketing and foreign investment group, and he's based in Ottawa. Before joining Fasken, John served for a number of years as Canada's Commissioner of Competition, the chief antitrust enforcer in the country. And before that served really in all units of the Canadian Competition Bureau, including mergers and cartels. Janet Hui is a partner with JunHe, based in Beijing. Janet has more than 25 years experience providing advice to clients in various industries, including natural resources. Janet's widely regarded as one of the leading competition lawyers in China, and we're very pleased to have her aboard. And finally, Josh Shapiro is a partner in the Antitrust Competition and Distribution Group at Thompson Hine. He's based in Washington, D.C. Josh routinely guides his clients through the review of M&A transactions by the U.S. antitrust agencies, the Federal Trade Commission, and the U.S. Department of Justice. He's also Thompson Hine's go-to person for strategic advice and counseling on critical competition questions. So welcome to our panel, and I encourage you to look at their the panelists' more ample biographies at your convenience. So our format today is that each panelist will provide a high-level overview of the antitrust merger control framework in her or his jurisdiction. We will then discuss recent important developments for mining mergers in an interactive format, and we will conclude by addressing questions from you, our audience. Incidentally, there is a question button. Feel free to submit questions. We will take them at the end. So I'd be remiss if I didn't point you to the materials on the site. The panelists have assembled a multi-jurisdictional merger control table, a number of slides relevant to their jurisdictions. There's also an article there, and as I've already mentioned, the biographies. So I encourage you at your convenience to have a look at those. So with that, by way of introduction, let's get underway. Katrina, perhaps you can start us off with respect to a high-level overview in relation to Australian competition merger law.
Thanks very much, Tony, and it's great to be here and have the opportunity to participate on the panel. I just want to talk briefly in the introduction about the who, the what, and the when of Australian merger control. The relevant who is the Australian Competition and Consumer Commission. They're an independent statutory authority and they're responsible for investigating and enforcing mergers in Australia. They are a very highly regarded and very experienced regulator. They're led by Rod Sims, who's been their chair since 2011 and will continue to be their chair until 2022. In terms of the what, the test in Australia is broad. It captures potentially any acquisition of shares or assets. Particularly with respect to shares, there's no requirement as to a controlling shareholding. So minority shareholding transactions can also be caught, and of course, joint ventures as well. When we come to the when, you're going to have to worry about merger control. There are two main features of the Australian system that distinguish it from some others. The first is there is no formal notification regime. And the second is that predominantly the system is entirely informal. That means that if you open the Competition and Consumer Act in Australia, you'll see no reference to the informal merger clearance process, which is actually the process that almost all mergers in Australia go by. Instead, the clearance process runs by way of guidelines and the experience of the practitioners and the ACCC who run it. There are also, in terms of the clearance of mergers, there's no immunity as such. What parties receive is a letter of comfort that simply says that if the transaction proceeds, the ACCC won't actually intervene to stop it. So those are key features that's very important to keep in context. In terms of thresholds, while it intends to be a qualitative exercise that totally depends on the transaction, the ACCC does have guidelines and identifies transactions where there are products or services that are complements or substitutes, or where the combined merged entity would have 20% of the market. So those are the rough markers, which will be very familiar to most competition practitioners in the area. The test that we're looking at in Australia is, does the merger substantially lessen competition or is likely to in a market in Australia? And substantial simply means that it's likely to have a material effect on the competitive dynamics of the market at hand. When we talk about markets, we're generally looking at specific products, geographies and functions, as we do in other jurisdictions as well. In terms of time, there's no set maximum timeline within which a decision must be made. Instead, there's a two-phase process. Most mergers are dealt with in a phase one process, which goes from about 6 to 12 weeks, including public market inquiries before the decision is made whether or not to clear the transaction. For those that go to phase two, where the ACCC issues a statement of issues, it's generally another 6 to 12 weeks. That said, one of the trends that we're seeing here is the ACCC for contentious mergers taking much longer than that and being very clear to the market and to parties that they will take as much time as they need. In terms of remedies, where a party does not have a transaction cleared and disagrees with the outcome the ACCC reaches, the remedy then is the federal court. The ACCC can only enforce its view through the courts in Australia, and it's the federal court that we look at. Just very briefly at the end, there is another pathway for merger control by way of authorisation. That has only been in place for the last 3 years. There's only a very small number of mergers that have used it. The informal merger process is really the one that's predominantly used. And in the authorisation path, it is a slightly different test, where if the ACCC forms the view that the merger is likely to lessen competition, it can then go on to see whether there are public benefits that outweigh that potential lack of competition. And if authorisation is granted, unlike the informal process, it does grant immunity, but it's a much more public and much more structured process. I'll probably leave my comments there just by way of introduction, Tony.
Thank you, Katrina. Amadeu, would you take us through the situation in Brazil, please? High-level overview.
Yes, with pleasure. And hello, Tony, and hello, everyone. It's really a pleasure to be here and to join this distinguished panel. I will walk you through first the thresholds in Brazil, and I will talk a little bit about the review process. To begin with, the antitrust authority in Brazil is known as CADE, C-A-D-E. It comprises 2 departments, the general superintendents and the tribunal. Cases reviewed and approved without remedies are reviewed by the general superintendents. Only cases that are the subject of remedies to be approved or blocked go to the tribunal. The thresholds in Brazil for transactions to be subject to mandatory notification, 3 tests must be met. One is effects in Brazil. That is largely the case of mergers that involve assets in Brazil or where the parties have exports to Brazil. Then the concentration test. And here Brazilian law is different, I think, than many jurisdictions in the sense that it contemplates as concentration not just mergers or acquisitions of control, but also joint ventures are loosely defined in Brazil. So joint ventures that you would not consider to be notifiable in other jurisdictions may be notifiable in Brazil. Minority shareholding acquisitions. And here we have a twofold rule. Acquisitions of 5% or more, if the parties are horizontally or vertically related, may be notifiable. And then acquisitions of 20% or more may be notifiable regardless of overlaps. Finally, there is a concept of collaborative agreement that can also be deemed a concentration under Brazilian law. And that is a somewhat unusual concept, but it does exist in Brazil and it triggers filings on a regular basis. Here, essentially, the parties are collaborating, and that means essentially agreeing to a common enterprise and then sharing risks and profits with respect to a certain project. And then the parties need to be competitors. If that is the case, and if we have an agreement of at least 2 years, we satisfy the concentration test. So be careful with those exceptions that I think exist in Brazil under the concentration test. Finally, the revenues test. So here in Brazil, we have a test that that essentially applies to the revenues of the groups involved in the transaction, both the buyer group and the seller group. And then you have to take into account their Brazilian revenues. Currently, approximately 140 million US dollars, one group, and then $14 million, the other group of revenues in Brazil. The three tasks that I have mentioned are cumulative, meaning you have to satisfy all three to trigger a filing. If you do have a filing, then the majority of cases is cleared without remedies in what we refer to as the fast track proceeding. The fast track proceeding is a proceeding with a simplified form where clearance is obtained in up to 30 calendar days from filing. Cases benefiting from the fast track are those where the combined market shares of the parties do not exceed 20% in horizontal cases. In vertical cases, no markets where the parties may have at least 30% market share. And then also some cases where, let's say, the HHI variation is minimal or there's very little nexus on a case-by-case assessment. And those cases will then, as I said, be approved in 30 calendar days or less from filing. Then we have what we refer to as the regular proceeding. And here, the review period can go anywhere from 30 days to 330 days. So it's a very wide range of possibilities that we have. But in most cases, they especially those that are approved without remedies, there is a pattern of having these cases approved in 60 to 90 calendar days from filing. However, in regular proceeding cases, you do have a pre-notification period to be added where the parties discuss the draft of the notification with the authority. That period takes usually up to 30 days, so that period needs to be added here. All other cases, more complicated cases, the cases involving remedies, these are really a case-by-case assessment. You have different. We've had different experience with the Brazilian authority in those cases, so much so that producing an average would not mean too much. So with that, I think I'll turn it back to you, Tony.
Thank you, Amadeu. Over to you, John, for Canada.
Thank you, Tony, and hello, everyone. And it's a real pleasure to be here at my first PDAC conference and event. I'll be speaking at very high levels about the merger control system in Canada. The Competition Act establishes jurisdiction for the review of mergers in Canada, and the Act is administered and enforced by our Competition Commissioner, currently Matthew Boswell, with the support of our Competition Bureau. It's an independent law enforcement agency. And while the Commissioner and the Competition Bureau investigate and evaluate the mergers, only the Competition Tribunal, a specialized quasi-judicial body, can issue a formal remedial order with respect to a merger. So under Canada's bifurcated approach to investigation and adjudication of mergers, the Bureau has broad powers of investigation, including the ability to subpoena documents and examine witnesses under oath. And the tribunal has the power to dissolve mergers or order divestitures. And a breach of our tribunal order may be punished by contempt proceedings. And appeals from the tribunal go directly to our Federal Court of Appeals, and from there to our Supreme Court of Canada. So all mergers with a nexus to Canada, regardless of size, are potentially subject to investigation by the Competition Commissioner. High-value mergers meeting our statutory review thresholds must be notified with our Bureau. And under current thresholds, where the purchaser and the target together have either assets or combined gross revenue from sales in Canada exceeding $400 million, and where the target business has either assets or gross revenues from sales in Canada that exceed $93 million, the proposed transaction must be notified with the Competition Bureau, and it must observe applicable waiting periods. There is a caveat: unless a pre-clearance is obtained through what's called an advance ruling certificate, which are only available for no competition issue mergers and are rarely issued by the Bureau. So statutory waiting periods will not commence until a complete filing has been made. The initial waiting period, like in the US, is 30 days. before which parties often receive a no action letter for non-complex matters. Most mergers are not reviewed beyond that period of time. There's very few complex and very complex matters. But for those complex matters, parties can expect to receive a request from the Bureau, a formal request, looking for additional information known as a supplementary information request, known as a SIR. This formal information request triggers a second 30-day waiting period, which only commences following completion by both parties of their respective SIR responses. Sometimes for the complex transactions which raise competition concerns, the Bureau review can extend beyond the second waiting period. In these types of cases, the Bureau can request and the parties can agree to extend the waiting period through what they call a timing agreement. In the alternative, the Bureau can seek an order from the tribunal to delay the closing. So most parties try to be cooperative to avoid litigation. So a remedy can be offered by the parties and accepted by the Bureau at any stage of the merger review process. And where the Bureau believes that a proposed merger is likely to lessen competition substantially, it will generally seek to reach a negotiated remedy with the parties, which is registered with the Competition Tribunal in the form of a consent agreement. And if a settlement can't be reached, the Bureau can apply for up to 1 year following the completion of the merger to the tribunal seeking a remedial order. In some of the cross-border transactions where remedy has been agreed to in another jurisdiction, typically in the US or in Europe, the Bureau has insisted on the same or similar remedy in Canada. Where there is no unique Canadian issues involved in the merger, the Bureau does not require any Bureau-specific, Canada-specific remedy. It relies on the other jurisdictions. And another note, to avoid gun-jumping investigations, the parties must act independently until a transaction closes. I think this is very important. As for the substantive test, it's similar to most jurisdictions. The competition analysis will determine if the proposed merger will create or enhance any market power for the merged entity. That is, will they have the ability to control price in a product market following the merger? And this analysis is usually conducted by the Bureau through merger simulation econometrics. And the simple proxies to market power determination can also be found in their merger enforcement guidelines. So generally, where you have post-merger market shares resulting from a merger above 35%, there'll likely be a more in-depth review. And where there's a concentration ratio of about 65% post-merger for the top 4 firms, that can also trigger a more deeper dive with concerns of coordinated behavior following a transaction. I just want to put out a reminder that care should be taken in the preparation of internal documents by the company and emails regarding a proposed merger. One should avoid using self-incriminating language to describe the benefits of a deal, such as it will allow us to corner the market or we will be able to increase prices after a merger. Should the Bureau uncover these hot documents during its review, it could crater your transaction. So warning. Lastly, the Competition Act in Canada contains an explicit efficiencies defense under which efficiency gains generated by a proposed merger can be used to offset any anti-competitive effects. The Bureau and the Tribunal have approved anti-competitive mergers on the basis of cost savings from a merger that are generally greater than the harm to competition from a merger. And I'll talk a bit more about that later. So that's it for me, Tony.
Thank you, John. Our next panelist to speak is Janet Wee from China. Janet, over to you.
Yeah. Yes. Yeah. Thanks a lot, Tony, and thanks a lot for organizing this webinar, and the pleasure and honor to talk to you and also with all the speakers. For China, we have the mandatory merger review process since 2008. And in the past, it's rather confusing because we have 3 antitrust agencies and the Ministry of Commerce, MOFCOM, in charge of the merger review. But at the same time, it also needs to consult the other 2 antitrust agencies for investigations. Fortunately, the 3 agencies were merged into one in 2019, the last quarter. There has been a short transition period, but now everything seems to be very smooth. So we would expect, high efficiency, especially for simplified procedure. But let's back to the basic. It's like all other regimes which are mandatory for merger review, so you cannot close a transaction before you obtain a clearance in China. In terms of what may constitute a concentration, it's more like other jurisdictions that you have the mergers, you have the acquisition of shares and assets. But one thing that's important for mining industry is that we also catch contractual arrangement. So the contractual arrangement is not just limited to JV, so we include all kinds of a JV, but at the same time, even for unincorporated JV or just the so-called, contracts, cooperation among the parties, including very common in mining industry, could be caught as well. So we have to review that carefully. Secondly is that the thresholds, turnover thresholds to be met is actually quite low. I heard that in Canada, we are talking about 400 million Canadian dollars. But now the threshold we are talking about each of the undertaking in last year's 400 renminbi only. So I think it's around maybe 20% of the threshold in Canada. And then added all together, that would be, either 10 billion renminbi or 2 billion renminbi for China revenue. So it's quite easy to be met. And at the same time, for this kind of arrangement, it's quite a long process in China because we have the so-called pre-acceptance. It's more like the pre-notification, which is a mandatory period, and SEMA has discretion in terms of how long it will take. Generally, it will take about a month, but sometimes it could be a long one, say 4 to 5 months, even for pre-acceptance. And then for the formal statutory period, we have 3 phases. Phase 1 is 30 days, phase 2, 90 days, and phase 3, 60 days. And it's actually quite common for the normal cases that will last for 6 to 8 months, including those without remedies. Fortunately, we have the simplified procedure, the so-called fast track, that started to implement in 2014. So whoever for the horizontal overlap less than 15%, the vertical less than 25%, it will fall within the simplified procedure, and it could take around, say, 6 to 8 weeks, and sometimes maximum 3 months. So that's quite quick compared with the normal procedure. Unfortunately, as you might have heard, that China is always the first in and last out. So we normally take longer than other cases, especially with remedy imposed, because even if you come to the expire of phase 3, it's not uncommon that with remedies that we have to pull and refile. And so just to give you an idea, for the conditional approvals in 2018, it took around average 420 days. So it's longer than a year. And then in 2019, even though it has improved, we're 390 days. For conditional approval on average. So I think for cases, with remedies, we have to get prepared with the long period of time. And then at the same time, it's actually quite stringent in terms of the gun jumping. So we have the first Canon Toshiba case, which in terms of a series of events or steps, but if SEMA regard that as one transaction, then even with the first step without the control right, it will be deemed as gun jumping. So that's something that we have to be aware. And at the same time, SEMA also have a right to initiate investigations for those transactions that do not fall within the turnover thresholds. And if they believe that there's anti-competitive effect in that transaction, then the investigation is actually as long as the normal review process. So this is also something that we have to watch out. And lastly, in terms of the remedies, the conditional approvals, we only have one case involving the mining industry, but the threshold is actually, the market share data is actually quite low. It could be less than 20 or 30%, but MOFCOM at that time regard that transaction may have anti-competitive effect. And so they have imposed a remedy for both structural divestiture and also behavioral remedy. And maybe we can discuss that more in the coming panel. Thank you.
Thank you, Janet. And just to clarify one point about the Canadian thresholds, the parties threshold is indeed 400 million. The transaction threshold is currently 93 million dollars, Canadian dollars. Our next speaker on this high overview approach or topic is Josh Shapiro on the US. Josh, over to you.
Thank you, Tony. It's a pleasure to be here today with you and the rest of the panel. I'll try to be pretty brief. You know, we could all spend the entire session talking about our respective jurisdictions. But in a nutshell, there are two main statutes, federal statutes, that are important here for mergers. The first one is one that's Section 7 of the Clayton Act. And the Clayton Act is over 100 years old now. And in essence, what the Clayton Act does is prohibits transactions where the effect of the acquisition is to substantially lessen competition or tend to create a monopoly. Section 7 applies not only to acquisitions of stock in non-corporate interests like LLCs, LLPs, anything that's not incorporated, but also acquisitions of assets, as well as joint ventures. Now, that's the overall statutory authority, which provides for the and there are other statutes that provide authority give the authority to the Federal Trade Commission in the Department of Justice to enforce those statutes. What most people are probably familiar with is the Hart-Scott-Rodino Antitrust Improvements Act, which is commonly referred to as HSR. And HSR requires parties to file notifications with the FTC and DOJ and observe a waiting period. It's a mandatory 30-day calendar day waiting period. The HSR rules are hyper-technical, and there are a number of exemptions. And typically you'd want to get counsel involved if there's any chance of a HSR filing. But put broadly, most transactions valued over $92 million will be reportable. And $92 million is the size of transaction threshold. There's also a size of person threshold. But again, as a rule of thumb, if a transaction is over $92 million, from a screening perspective, you want to consider whether it's HSR reportable. This size of transaction test is adjusted annually based on the change in the U.S. and gross national product. Interestingly, this year, it was the first year in well over 10 years in which the size of transaction test actually decreased. Usually it increases several $1 million a year. A key thing here to note is that transactions that are not reportable under the HSR Act, either because the thresholds aren't met or because an exemption applies, are still subject to Section 7, which is the first statute I mentioned, the one that's 100 years old. What this means is that even non-reportable deals, and this is sort of different from other jurisdictions, non-reportable deals may be investigated and ultimately challenged by the U.S. antitrust agencies. A couple other important things to note here is that, number one, there's no statute of limitations. So unfortunately, even after a deal has been consummated, agencies can challenge deals, both non-reportable deals, several years down the road, as well as deals that have actually undergone HSR review. That's not a lot of comfort for companies. I understand that. But what I would say about that is that, sort of the general mantra is it's very difficult to unscramble the eggs, so to speak. So chances are, if you've gone through HSR review, you're probably okay. There's typically, from a practical perspective, a higher bar for the agencies to challenge deals that have already been consummated. One other kind of quirk in U.S. merger control law is that private claimants can also bring civil suits to enjoin proposed transactions and also seek damages for completed ones. I'm going to speak briefly about the process here. Again, we could spend a lot of time going through this, but as I mentioned before, there's a 30-day waiting period that must be observed, under which the parties can't close the transaction until the period is expired. That waiting period is actually, in certain circumstances, is 15 days, and there are two instances. Number one, in the case of a cash tender offer, and the second, in the case of certain acquisitions and informal bankruptcy proceedings. The FTC, which is the FTC's pre-merger notification office, manages the receipt of HSR filings. There is an office at the DOJ as well, but the FTC had what's called the early termination program, where you could apply to receive early termination of that period, waiting period. Unfortunately, that early termination program is currently on pause. The length of that pause is indefinite. It was announced in early February. There's some speculation whether it'll come back in some form or fashion, hopefully in the next few months. A little bit more about the process. At the end of the 30-day waiting period, the investigating agency, which could either be the FTC or DOJ, both agencies have concurrent jurisdiction over mergers, but typically one takes certain transactions over the other. For example, the FTC usually investigates mining mergers. At the end of that 30-day waiting period, the agency has to make a choice, and they have to decide whether to let the waiting period expire or issue what's called a second request. And the second request is akin to a phase 2 investigation in other jurisdictions. And that sort of if you are in a phase 2 investigation, that can take several months to resolve. It's a very onerous process, a lot of documents, a lot of information has to be provided to the government. And then either you can decide to sort of put the onus on the government to decide whether to sue you and try to block the transaction, or you can pursue remedies. One other thing, and John mentioned this as well in the context of Canada, U.S. merger control investigations really rise and fall on the strength or what's in the documents of the parties' documents themselves, and that's something that people should be mindful of, particularly as you're sort of preparing for any deals. What goes along with the HSR filing, which includes a lot of information about the companies, about the deal itself, are documents prepared by both the acquiring and acquired parties. These are documents prepared by the business evaluating the deal, and those are sometimes the critical reasons why an agency decides to ultimately challenge a transaction. And back to you, Tony.
Thank you, Josh. So that takes us through the high-level overview. And what we're going to do now is get into a discussion of specific issues. Now, I should mention that what we did was we canvassed each panelist to select a bunch of issues. The fact is we could stay here all day on any one issue. Needless to say, we don't have that time. So we're going to start with market definition. Market definition is like, as in any industry, market definition is pretty central to competition analysis in mining mergers. And I'm going to start with Josh and ask him to comment on the Peabody Energy and Arch Resources transaction or proposed transaction, which was largely decided on market definition grounds. And Josh, when you're commenting on it, you might include in your remarks whether whether the finding of the court, appropriately a court in Missouri, the show me state, whether the finding was a surprise, and if so, in what respects, and takeaways for mining companies from the decision. Over to you, Josh.
Sure. Thank you, Tony. Just a bit of background. This is a case that was resolved in 2020. It was a proposed joint venture between Peabody Energy and Arch Coal, which would have combined the parties' coal mining and sales operations in the Southern Powder River Basin, which is a area of northeast Wyoming. And the FTC challenged the deal and claimed a very narrow product market definition. And the product market definition was specifically coal mined from the Southern Powder River Basin. And this is thermal coal that was used for a generation of electricity. The FTC alleged that the proposed joint venture would eliminate head-to-head competition between what really were the two largest suppliers in that region, and two of the largest coal miners in the United States, or among the largest in the United States. And Peabody actually was the largest. The allegations here, and this was not really disputed by the parties, is that at least within the Southern Powder River Basin, the joint venture would have put in really Peabody's hands, which would have controlled the joint venture, a very formidable share of the coal reserves and coal production there, exceeding 60% of that. And ultimately, the federal district court in Missouri, of all places, granted the FTC's request for a preliminary injunction. And following that, the parties abandoned the deal. Notably, this was actually the only deal in the United States that was formally prohibited in 2020, meaning that a federal district court granted a request for a preliminary injunction. There were other deals that were abandoned following the agency's pursuing a preliminary injunction, but this one went through a hearing. And as Tony mentioned, market definition was key here. And this was really the critical issue, as it is in most merger investigations. I wouldn't say it was particularly a surprise because this is where cases rise and fall, at least in the U.S. But there was an industry recognition, or at least from outside observers, if you weren't following the thermal coal specifically, you would say, well, coal is particularly coal used for electricity does face competition from natural gas and other renewables such as wind and solar. In fact, the court actually acknowledged that was the case. It acknowledged that competition. However, and this is again sort of the principle that we have to remind ourselves of, is that at least in the United States, from an analytical perspective, courts will take the narrowest market principle, which means that even if there is a broader product market, one that would include coal and natural gas and renewables, they're distinct submarkets. And if in any of those submarkets, there would be competitive harm, substantial competitive harm, under the Clayton Act, the joint venture would technically be illegal, and that's essentially what the court found. And the court, it was interestingly enough, it was a judge appointed by Trump, which was surprising to some. Gave a very reasoned and very analytical opinion that went through the FTC and defendants' arguments, and ultimately found for this very narrow product market, and actually was a relevant product market that was specifically coal in the southern Powder River Basin. And that was the product market. The geographic market then followed, well, clearly it's in the southern Powder River Basin, so it sort of followed from that. So it flowed intuitively from that product definition. But again, it was, the court credited the defendants with a lot of the arguments that they were making, specifically around the intense pressure that they were facing from other forms of other fuels to generate electricity, but ultimately found with the narrowest product market definition, it was coal. So again, we have to sort of think through in terms of future mining mergers. I think the lesson here would be, even if there is competition from other sources of other minerals, other sources. Again, we have to sort of start narrow and then look big. So if market share, market concentration are all relative. It depends again at what level you're looking at.
Thanks, Josh. So the next question I have for you relates to the Biden administration. Competition law observers of the U.S. Antitrust field are predictably speculating as to the implications of the new administration, both in terms of enforcement policy and perhaps even legislative reform. I wonder if you could, in a couple of minutes, just give us your take on that.
Sure, happy to. Tony, there's been a lot of speculation around the world, and particularly here in the U.S. and the U.S. antitrust community, about what the leadership at the DOJ and FTC will look like. It's coming into, there's a lot of speculation about who will be appointed in particular, and also about Biden's specific enforcement priorities. I would say President Biden is already under a lot of pressure. The Biden administration really is under pressure from progressive critics of corporate consolidation to avoid appointing lawyers, for instance, who have ties to the industries they'll be tasked with overseeing. A lot of that pressure is coming related to big tech, so it's less of an issue for mining, perhaps. But I'll give you an example. There was considerable pushback when there was press reports about a rumored short list of nominees that included outside counsel for Google and Amazon. So clearly on issues of, sort of the focus of antitrust enforcement, I think over the next couple of years likely will be on big tech. And there's actually, some agreement on both sides of the aisle, for somewhat different reasons, that's a good thing. But I do think that there is a sort of a larger undertones of critiques of corporate consolidation, and that can flow to different industries, including the mining industry. And as we've seen, with Peabody and Arch Coal, again, that was out of a number of challenges actually last year. That was the one that ultimately was went the distance, was formally challenged, and was the court upheld that. So again, I think as it for certain industries, particularly in certain industries in the mining industry, where there's pressure, and particularly if you look at coal, for more corporate consolidation because of perhaps dwindling revenues, it's gonna sort of really come up against this sort of tide of rising antitrust enforcement. So it remains to be seen. But again, I think the prediction is that there will be greater antitrust enforcement, although the question is greater from what? Because during the Trump administration, even though, traditionally you'd say, well, in a Republican administration, there'd be less antitrust enforcement. There actually was quite a bit of antitrust enforcement at both the FTC and DOJ. And traditionally as well, the FTC and DOJ are seen as independent, relatively independent agencies, with some notable exceptions over the past couple of years during the Trump administration. For the most part, there was very active antitrust enforcement. So I'm just not sure. If you look at last year, there were 20 consent decrees by both the FTC and DOJ. It was up from 17 in 2019. It was actually some of the, there were 11 deals that the agency sued to block. So again, the question is more antitrust enforcement. That's actually quite a bit. So again, we'll have to see where the chips fall. But again, we're sort of, we're in a situation where we're waiting to see. But on the other hand, we're already kind of in the midst of a pretty active period from the FTC and DOJ.
Thank you, Josh. We will watch that with great interest. So moving to Janet for China. Janet, first question. I understand, mining transactions are often, of course, multi-jurisdictional. And I understand that when seeking to clear a multi-jurisdictional transaction in China, special considerations exist in terms of the process before the State Administration for Market Regulation regime. Perhaps you could comment on that.
Yeah, I think in terms of the multi-jurisdiction regime, the difficulty now rests with the merger review in China is that there are always non-competition issues that may be involved. And I think the most obvious one in the past is probably that where, two important factors. The first factor is that, SEMA, especially for high-profile cases, they always care very much about what are the attitude and also the decision of other key jurisdictions. And those key jurisdictions mainly involve US, Japan, South Korea, and European Commission. And I think among all those regulators, probably European Commission is the one that they care the most. And so even in some cases, SEMA may ask for copies and translations of all the RFIs and responses in the key jurisdiction, especially for Europe. And even for some issues that may be not China-focused, they are also interested in knowing. And so for this kind of multi-jurisdiction merger review, SEMA tends to wait until all the other regulators raise all their concerns, impose remedies, and have the clearance issued before SEMA is willing to grant clearance. They want to make sure that they have not overlooked anything. And so this will cause long delay, especially for some cases. We got clearance in all other jurisdictions,
but SEMA maybe need another 3 to 5 months or even longer before it grants a clearance. The second thing is the political tension among the countries. Lately, as we are well aware, with the Trump, presence, we have, a long debate as to whether certain transactions needs to be cleared or wait longer until Biden administration comes on board. So we'll see, for example, like the Lakers Cisco Acacia case, that we do not get the clearance until the Trump presidency is over and Biden administration comes on board. And you can see that sometimes the antitrust regime may be used as a political tool in case that there's conflict. So there are all other cases, for example, the KLA Overtech, which they're, in the market, they may be saying that there's non-competition issue, but at the same time, remedies are imposed, and including, say, Bing Toshiba, GamePact Toshiba case, which they have waited, longer than other jurisdictions. Well, the latest jurisdiction that we are not a friend, maybe Australia, there has been quite a serious tension. And in case of mining cases for involving Australia, we also anticipate that there may be longer delay because of the unfriendly relationship. And at the same time, in the past, you will see that for Japan, South Korea, and also some other jurisdictions, there may be tension and there may be put on hold for the merger review process. And so other than that, there also, that's a foreign investment issue, which now in China becomes less an issue because we have relaxed the foreign investment. But at the same time, when we see that in Europe, that there are, heavier scrutiny, and we will see that Europe has imposed that sort of white paper in China. So the tension may become more severe. And again, for this kind of issue, it may end up that have a longer delay in terms of review process in China. So in advising this kind of a multi-jurisdiction review, we would suggest that the parties actually do a couple of things in advance. The first thing is that SEMA sometimes may use the economic analysis as the basis to support that they are not political issues. So they will hire their economists and put out paper to argue that they're competition concerns. So hiring the economists in advance to prepare the report may be one way to solve the problem. The other way is that we also recommend the client to have the government relationship or government affairs councils hire in advance. It could be multinational companies with that role, or they have their own GR council in place. And so we would have to talk about what are the stakeholders that may be consulted and what are the advanced communication in order to solve that issue. And of course, sometimes if that's very high officials involved, then we have to talk to the client about whether they can get the local government involved to assist them and in any other ways to resolve the issue. So actually, I think for this kind of mergers, we have to look at that from a strategic point of view right in advance before the issues come into place.
Thank you, Janet. Fascinating. I've got a number of questions, but alas, time constraints. So I'll move to the second question for you, and that relates to joint ventures. So obviously, in the mining arena, joint ventures are not at all uncommon. Are there special considerations, or perhaps you could just comment with respect to SAMR's view of, or the SAMR view of joint ventures in China?
Yeah, thank you very much. I think joint venture has become, a tighter scrutiny for SAMR. As you may be aware that there has been a conditional approval case imposed remedies on a joint venture, and actually is one of the longest review period, more than 450 days, I think. So SEMA is aware that sometimes the parties, instead of entering into the so-called cartel agreements, joint venture may be a disguise in this kind of a collusion arrangement. And so it's not just for high-profile case or the normal procedure, even for simplified procedures. SEMA now is looking at from the cartel perspective and asking all kinds of questions to see whether there may be horizontal issues between the joint venture. And then you can see that some of the remedies imposed that actually it should be revert to the investigation for collusion. But sometimes SEMA would impose the condition in order to prevent that sort of cartel or collusion among the parties. And I think for mining industry, the problem is that, for contractual arrangement, SEMA also will want to review and to what extent that sort of contractual arrangement should be reviewed. For example, is that in the exploration stage, or that has to be in the, mining and sale of product stage. So we have been engaging in this kind of discussion with SEMA, and it seems that they would like to intervene at quite early stage for the joint ventures or the unincorporated joint venture contractual arrangements. So I think the parties would have to be very careful if the joint venture may be regarded as a horizontal agreement.
Thank you, Janet. So just having regard to time, why don't we move to John Pecman, Canada? And John, a couple of things. So Canada has a somewhat unique regime with respect to efficiencies. I wonder if you could comment on that, given that at least in some mining markets, there's a high degree of concentration, and so but for an efficiencies story, it may be that the merger can't be accomplished. Over to you, John.
Thanks, Tony. Yeah, it's true that Canada has this efficiency defense that is quite unique. You don't find it in any other jurisdiction around the world. South Africa has one, but doesn't use it. And it's been used quite frequently in Canada. And the thinking behind the legislation was Canada being a smaller country, trying to compete with larger, with companies that are larger and larger jurisdictions. Some concentration in Canada is tolerated, and it goes in keeping with the Chicago School of Efficiencies. Should be one of the driving factors behind competition law. Canada has embraced that concept and has this defense where if an anti-competitive merger that could increase prices can be approved where it's found that these cost savings are greater, and when they're quantified, are greater than the negative effects. And a number of mergers have been approved by the tribunal. Superior Propane, when it acquired ICN, almost a merger to monopoly, was approved following litigation. Trevita, Supreme Court of Canada, ultimately approved that transaction of hazardous waste materials depots in British Columbia. That was approved on the basis of efficiencies, even though it was a merger to monopoly. And after that Supreme Court of Canada decision, the Bureau, the Competition Bureau, took it upon itself to do the analysis and approve efficient mergers, even though they could be harmful to consumers. And so we've seen a number of those: Superior Connexus, Cargill, La Cooperators, the local co-op transaction. So it's as I said, it's unique, it's different, and with econometric techniques today, the quantification of harm is done. There's a big data collecting exercise of pricing data, and the harm is measured, and that is again weighed against cost savings. However, if those that are involved in mergers, the justification for them is often cost savings, and many are not realized. But there's claims are made, and so the Bureau is wanting to verify more closely to determine whether some of these claims will in fact come to fruition. And as a result, they want to spend more time looking at the claims, and have introduced a new model timing agreement, which is being used to give them more time to assess the claims. only after they've determined that there's going to be anti-competitive effects from a merger. So the parties are asked to enter into this timing agreement with the Bureau to hold off closing until they finish their assessment. And the assessment includes things like hearings under oath of executives to question the claims that have been made, and also to hire experts to help them with business valuation issues. So the upshot is this new timing agreement. Any company that is trying to have a deal approved based on efficiencies can expect to have closing delayed for up to 100 days now in Canada, which is beyond the statutory layout in our legislation. So again, it's just a heads up on the efficiency defense. But for companies, it's in Canada especially, it's a net positive for those looking for increased consolidation in their sector.
Thank you, John. Turning to fascinating again, lots of follow-up questions, but we'll have to leave that for the time being. The Competition Bureau recently restyled its merger notification unit as the Merger Notification and Intelligence Unit, MINU. And the reason is that they were concerned that because of the high-ish thresholds for transaction thresholds, they were missing a lot of mergers that might be problematic. So I wonder if you could comment, John, on the essentially build on the rationale, the explanation for that initiative, how it is that the Bureau is getting information, and generally how businesses ought to plan for that aspect, that development.
Yeah, thanks, Tony. In Canada, like the US, non-notifiable mergers can be challenged by our authority, by the Competition Bureau. And smaller transactions are on the radar internationally, and it's largely driven by big tech issues. Concern being big tech is acquiring nascent firms, really tiny firms that could become potential competitors, and as a result, it's heightened the authorities' concern with smaller transactions. So the Bureau announced in May of 2019 it was going to invest additional resources into their merger notification unit. And my understanding is they are now using artificial intelligence tools to scan the internet, looking for these deals in Canada or that affect Canada, with the potential of actually challenging those transactions that have not been put on their radar screen. So small mergers are now something that the Bureau is investing more and more on. Traditionally, those types of deals came to the Bureau's attention through complaints. A competitor or a customer concerned about a smaller deal would call up the Bureau and complain and put it on its agenda. But now they're doing it independent of the complaint process. And as a result, we've seen at least a couple of non-notifiables challenged since this announcement. One specifically was an acquisition by the Canadian National Railway of H&R Transport involving certain intermodal shipping assets, which the Bureau ultimately approved but reviewed in detail. And it approved it, again, on efficiencies. The efficiencies outweighed the harm. It was an anti-competitive deal, but the Bureau allowed it to proceed or not challenge it on the basis of efficiencies. In addition, the Bureau is trying to speed up its investigations, not just in the merger area, but across the board, abuse cases, cartels. And Commissioner Boswell announced that they're going to rely more heavily on interim relief. And so we saw an example of that being used in the merger context last year in Tomo Bravo's acquisition of Exerna, a Calgary-based company that supplies reserve software to oil and gas producers. And the assets that were put into an interim hold separate order were ultimately divested through an order of the tribunal. But that deal from notification to the divestiture took place in 4 months. So that is quite speedy for a contested transaction in Canada. So we got smaller merger concerns and more use of interim relief in Canada for merger review is the bottom line here, Tony.
Thank you, John. So turning to Brazil, Amadeu, I wonder if you could comment on the interaction between CADE and the National Mining Agency and its implications for merger control.
Thank you, Tony. So CADE, as I mentioned earlier, is the authority in charge of reviewing and approving mergers. They have been, since 2018, collaborating with the National Mining Agency, which is essentially an agency in charge of overseeing mineral rights in the mining sector. This is a somewhat recent development that led to an increasing scrutiny of transactions in the mining space. The National Mining Agency, known in Brazil by its acronym ANM, they have been providing CADE with market data and also ANM's own views on the impact of mergers in order to assist CADE with the antitrust analysis of any given transaction in the mining space. These are non-binding opinions, but opinions that CADE does take into account. We have, by way of example, the same kind of dynamic between CADE and agencies in other regulated industries, such as oil and gas, telecom, etc. The result of that in the mining space is that, for example, in the past, historically, parties would provide information on their horizontal overlaps only in those markets where they have actual production, where they have actual output. A&M has been adding information to the analysis by providing CADE with details on the reserves owned by the parties, such that CADE would then consider, just beyond actual output, potential overlaps among the parties as far as their mineral reserves are concerned. And so that explains why we were likely to see more rigorous scrutiny of transactions in the mining industry going forward.
Thank you, Amadeu. Actually, picking up on the observation about stronger scrutiny of transactions in our preparation for this session, we talked about a couple of mergers, Vale Ferros and ArcelorMittal Votorantim. I wonder if you could comment specifically how the market definition went, in what ways the scrutiny was more deliberate, the time periods involved, and the types of orders granted, all in a couple of minutes.
Yeah, I'll try to be brief, and I'll highlight the things that I thought that I think are more important as far as the process in Brazil is concerned. We're seeing just in general greater scrutiny in Brazil of transactions. We've seen transactions being blocked or subject to significant remedies in recent years, more so than historically. And so, if you're planning for a transaction that touches on Brazil, a risk assessment regarding Brazil is always important. In the ArcelorMittal Votorantim case, that is a case involving primarily assets in the steel industry, and so the mining industry came by way of the fact that the parties had a vertical relationship in iron ore being supplied for the production of steel. And so the vertical integration itself wasn't really what caught my attention here. Ultimately, the transaction was approved with remedies. What caught my attention with respect to this case is that although Brazil has been, in recent matters, I think, stronger in terms of the enforcement, the CADE, the Antitrust Authority, is perhaps more flexible when it comes to remedies than other jurisdictions. In this case, in particular, the high concentration in steel markets could have led CADE to block the deal. Instead, there was a divestiture of certain assets, and then on top of that, to allow the deal to go through, ArcelorMittal committed to what they refer to as a performance commitment agreement, which essentially was a commitment to keep production levels high for a certain period after closing. In other words, by ensuring that output would remain high, prices would presumably remain at a relatively stable level. You would think that a remedy like this would be problematic in most jurisdictions, or unusual to say the least, but it was part of the remedies package. And so you can think somewhat creatively when it comes to remedies in Brazil, I would say. In the Vale Ferros case, this was a case where I'd like to highlight a procedural aspect of the review process in Brazil. This was a case where Vale acquired iron ore assets from Ferros, and the overlap was primarily in iron ore and the three relevant markets that we have within iron ore in Brazil. But the addition of market share to Vale's already quite high market share, frankly, in iron ore in Brazil was somewhat limited. Iron ore has been viewed in Brazil as a national or a regional market, meaning even narrower than Brazil-wide, around infrastructure existing in several regions in Brazil, meaning the markets have been defined on the basis of the infrastructure for the flow of iron ore to Brazilian ports. And then in this case in particular, what was interesting is that there was a vertical integration resulting from the case between certain infrastructure assets and ports, and then iron ore. And one of the parties that was affected by the merger complained. And then in Brazil, there's a rule by means of which, if you're admitted as a third-party complainant, the clearance decision, you can appeal against that decision to the tribunal. So once the general superintendents approved the case without remedies, that third party appealed and was able to substantially prolong the review process just by virtue of that appeal to the tribunal. So it's interesting to see this feature of Brazilian law where third-party complainants have this, what I think, significant right to appeal against decisions, clearance decisions, thereby prolonging the review process. Ultimately, the deal was approved without remedies.
Thank you very much, Amadeu. So turning to Australia, acquisition of minority interests are receiving increased attention by antitrust authorities around the world. Australia is no exception, I gather. And I wonder, Katrina, whether you could comment on that, given that minority interests are a common way of mining companies to secure financing.
Yeah, sure, absolutely. Thanks very much, Tony. And I was interested to hear John talk about the emphasis on that in Canada as well, and the focus on market intelligence. And in fact, the current minority shareholding merger that is front and centre in Australia concerns the acquisition by Qantas, which is our national carrier, of another airline or of a minority shareholding stake of about 19% in an airline called Alliance Airlines. That was not notified to the ACCC. They initiated an investigation themselves when they found out about the transaction. alliance is very relevant to the mining industry in Australia in the sense that basically they operate charter flights, and a prominent carrier on a number of the fly in, fly out routes that are used in Western Australia and Queensland to bring workers to the relevant mines there. And the ACCC basically has raised concerns about the influence that Qantas will be able to have on Alliance's operations post the transaction if it was to go ahead. They think they'll have a reduced incentive to compete with them just because they'll have an interest in their Alliance profitability as well. The merger puts Qantas in a position to limit Alliance's fundraising opportunities by potential investors, and therefore the Commission has said stifle its ability to be an independent competitor to Qantas. And they're also concerned that Qantas may use its influence as a shareholder to try and crawl some of the current arrangements in place between Alliance and its main competitor nationally, Virgin Airlines. And look, this is just a good example that the ACCC has now publicly said that this lies within its enforcement division, because that's the way they'd have to take action as the merger's now completed. But it does highlight some of the problems that the ACCC sees with minority shareholdings. We did go back and have a look, and this has been an area of focus for the last 10 years for the ACCC. And while they've made a lot of noise, they actually haven't blocked anything. Ultimately, they have looked at transactions where the shareholding has been as low as 10%. So it's definitely something to keep in mind. And picking up on, as Janet said, the sort of current state of the relationship between China and Australia has played out in the foreign investment review context, which I know we're going to come to with respect to a series of potential investments, which are, I think, around between the sort of the 8 to 15% mark in gold and a number of other minerals, which were all blocked and didn't get foreign investment review approval. So it's very important to remember that if you've got a transaction in Australia, regardless of the level of shareholding that you're acquiring, you need to look at the competition issues quantitatively, and mining is regarded as a sensitive industry.
Thank you. So a follow-up question. It's not unusual for, in the context of a mining transaction, to acquire related infrastructure, and that aspect can itself give rise to competition issues. Can you comment on that and how you manage those?
Yeah, absolutely. And again, interesting with Amadeu talking about their Vale case in Brazil, which involved, as I understood from your description, that access to infrastructure between the mine and the ports, which for some of the iron ore mines, which is of a critical nature for many of the Australian mines as well, some of which are located a considerable distance from the relevant ports. And there have been major congestion issues, really, with producers trying to be able to get their coal or iron ore to the port in a timely fashion and have sufficient capacity for the terminals to handle those minerals at the port to actually load them onto the ships. So the ownership of the railway assets, and if you're talking about gas transmission and distribution assets, are seen as highly valuable, as their like haulage contracts and also access to terminal capacity at ports too. And the ACCC looked at these issues in the context of the proposed BHP merger, Rio merger, which was obviously some years ago, but actually specifically looked at the supply of rail services and the supply of port services as a couple of the markets they were interested in. And more recently, in 2016, there was a proposed transaction in Western Australia that would have involved the consolidation of ownership of railway assets with one of the major users of those assets. And last year, there was also another case which the ACCC actually contested the acquisition by Pacific National, who are a large intermodal business, of a significant terminal, interstate terminal between two of our states. And ultimately, they lost that case. But in all those transactions, the Commission will be looking at what is the foreclosure risk as part of the merger transaction. So while one of the things people are often focused upon is just the sort of horizontal aggregation issues, in Australia, often that's not of such great concern. We really look at product markets usually as global supply markets because of how small we are and what we produce. But those infrastructure issues can be very problematic here, and they're very high on the Commission's radar. They're extremely sensitive to them.
Thank you. So that sort of concludes the formal part of our session. And what I'd like to do now is canvass the panel with respect to one question and that we have, and possibly two, depending on time. We are coming to the close of the session. So I'd like to ask the panel, and I'll start with Josh and John, because I think I know the answers and they will be punchy. And then we can move to the more challenged ones. So the fact is they're putting aside other agencies, such as in the US CFIUS, in Canada, the Investment Canada agency, putting that aside, to what extent do non-competition issues, be they environmental, be they national security, be they geopolitics, to what extent are they relevant? Clearly, Janet has already observed that there is some relevance in China to SAMR. So with that, I'll ask Josh to comment, and I'm hoping to canvass the entire panel on this, so please be brief with your responses, panelists. Thanks.
Don't worry, I will be very brief. And the answer is they do not, or at least they should not. Typically, and that's the complaint that many, particularly progressives on the left, have of antitrust that doesn't take into account other things like labor, environmental, et cetera. It just doesn't in the United States. The merger control focuses strictly on, the economic and price issues. So, it comes into play in certain mergers in certain industries where you have another agency reviewing it, and there's sort of a different public interest standard. But at least when a merger is just before the FTC or DOJ and they're looking at it from a strictly competition standpoint, it does not. And that's not to say it hasn't in the past in certain limited exceptions, but the general view is that it neither should nor typically does.
So, John, over to you, and I presume you're not going to dwell on the socially adverse effects
from, no, I'm not. I'm not going to go there at all. All to say is, like the U.S., like Josh mentioned, the authorities are independent of politics. They're agnostic when it comes to whether the companies are foreign or domestic in their reviews. The only two carve-outs involved or found in our Competition Act that allow for private public interest considerations deal with transportation undertakings and financial services, banking mergers, for example. Banking mergers, the Minister of Finance has final word. The Bureau will make a recommendation, but the Minister of Finance will take public interest considerations into account. And same with transportation undertakings, airline mergers, for example. Those transactions need to be filed both with our National Transport Agency and with the Competition Bureau. And the National Transportation Agency, it's the minister and cabinet that have final say, and they take into account public interest considerations such as employment guarantees, which was recently the case in the Air Canada Air Transat deal that Canada looked at.
Thanks, John. Katrina, Australia seems to be a bit of an aberration on this side, given the public interest component. Care to comment?
In the authorization space, Yes, so that if you are under the authorisation route for merger control, then yes, the definition of public interest is extremely broad and could take into account some of those notions, potentially including things like environmental impacts and impact on, we've seen it in the non-merger authorisation context, where you're looking at conduct with respect to the impact on the economic activity in a particular region, so wherever it's got a regenerative ability. So that's possible. I would say, though, that while that authorisation route exists in Australia, almost all mergers go through the informal clearance process where that is not available. So generally, my answer would actually be the same as Josh, that the ACCC is very strongly independent and apolitical. Where the political environment comes in is where you have a merger that also requires Foreign Investment Review Board approval. We did have a scenario in 2012 where the ACCC cleared a large merger in the grain industry, which involved the control of a whole series of grain terminals at ports around the country. The ACCC cleared it. The Treasurer blocked it on Foreign Investment Review grounds. And ironically, one of the grounds he blocked it on was related to competition, despite the fact the ACCC had cleared it. But that's an aberration generally.
Thank you. Thanks. Very, very interesting. Janet, you've already made an observation. Is there anything you wish to add in terms of non-competition factors in merger review in China?
Yeah, thank you very much. I think, other than the factors that I just mentioned, the local government intervention and also the local labor conditions will also be factors that they consider. But normally, SEMA would not intervene. The antitrust agency would not intervene, proactively, or they will show reluctance that it seems that they will be involved. But they will put the review process on hold and somehow give you pressure that you would have to solve the labor issues or economic issues or the government, local government issues before they proceed with the review process. So other than political issues, the local economic development and also whether the merger will cause more, loss of employment opportunities, etc., somehow have been intervened in an indirect way.
Thank you, Janet. And to close us out, Amadeu, in a couple of minutes or less, anything you wish to build on in terms of what you've already said?
Thank you, Tony. So in Brazil, the authority is apolitical. It is, I think, highly technical. And there have been in the past cases where politicians have attempted to influence the process. Those failed. It usually backfires. And so the analysis is strictly a technical one. The question is, will the analysis take into account only competition law issues or issues pertaining to other laws, such as environmental laws? Here again, CADE has been very strict in the enforcement of the antitrust law, making it clear in all cases that it will not take into account other laws in its analysis. The most recent example was this transaction I was just referring to in my earlier comments, the Vale-Ferros case. In that case, we had Vale, Brazil's largest mining company, as one of the merging parties. And you will certainly be familiar with the accidents involving Vale in the recent history of Brazil. The most recent one was the collapse of a dam owned by Vale in a city called Brumadinho. And that resulted in growing public pressure on CADE to consider non-competition issues in the merger review process. In that case, CADE has resisted that pressure. And although they were faced with pressure from different organizations within the civil society to make the approval of the transaction conditional to Vale fulfilling certain environmental and social obligations, CADE just reaffirmed its position that only competition-related issues should be considered. Thank you, Tony.
Amadeu, thank you very much. Well, to our audience, that brings us to the end of this program. We want to thank you, and I thank you on behalf of the panelists, for your time and attention. We have so much more we could discuss with you, but as you're well aware, we're at the end of our time allocation. Panelists, thank you very, very much for your very substantial efforts in preparing for this. With that, I bid you all have a good day.